trusted, they tip and they sway. The sword's been dulled, it's been locked away. The blindfold slips, revealing the game. Lady Justice, tell me, who do we blame? This isn't balanced, this isn't right. Who stole the stars from the flag tonight? Lady Justice, where are you now? We're screaming loud, but you don't hear a sound. This isn't the America I knew. Lady Justice, where are you? The gavel falls, but it don't make a dent. The halls of power feel broken and bent. Promises whisper and swept with the breeze. Truth gets tangled in the webs of greed. Blindfold torn and the swords in the dirt. The scales can't hold the weight of the herd. Oh, tell me, where did you go, Lady Justice? We need you so. Lady Justice, where are you now? We're screaming loud, but you don't hear a sound. This isn't the America I knew. Lady Justice, where are you? Lady Justice, where are you now? We're screaming loud, but you don't hear a sound. This isn't the America I knew. Lady Justice, where are you? Lady Justice, where are you now? We're screaming loud, but you don't hear a sound. This isn't the America I knew. Lady Justice, where are you?
Hi, everyone. How was everyone's Christmas? Do y'all have a good Christmas? Was Santa good to you? Thanks for joining. Oh, let's see who we have. Hey, Heather. Hebby. Let's see. We got Heather and 2 lurkers in here, which is okay. Well, anyway, I had a great Christmas. I went over to my family's house, got to play with my nieces and nephews. Was a little late. So I got some stank eyes when I walked through the door because I was in charge of appetizers. Yeah, I'm like, what were you guys thinking? No. No, it was trying to get us out the door and the dog situated. But you know what? My New Year's resolution is to be on time in 2026. What, 2026? That is mine. Has Heather, have you picked out your New Year's resolution? If you do that. And how was your Christmas? Yeah, so I am going on going to a wedding on New Year's Eve, which I thought was kind of strange at first, but I'm really excited because it's like got the DJ there, going to be around with family. My niece is getting married. My uncle had passed away about a year ago. So I'm sure it's going to be somewhat difficult, but a happy day for her. So I'm just really, really excited. And got an open bar, got my hotel room right there. So I'm really excited for that. And well, tonight, actually, I know it's like late on the East Coast, I'm going to talk about the torture of Richard Allen because he was tortured. So in preparation of this live stream, what I did is I went through and I found some court cases way before Richard Allen's case where there was some litigation and Eighth Amendment violations. So I'm going to walk through some of those examples, and then I am going to read the brief. And full disclosure, I only skimmed over it. So you're going to, for the most part, get my reaction live. And then we'll talk a little bit about how, mental illness, being in solitary confinement for as long as Richard Allen or anyone for that matter, then it definitely can cause psychosis. There's also something called I think it's SDHU syndrome or SDU syndrome. It's a thing. It's a mental diagnosis. So I'm going to go through that if there's enough time. So maybe I'll have to do this in 2 parts, but this is something that I'm really compassionate about. This is probably the most egregious, nefarious thing in this case that really bothered me. Even before we've learned about his confessions, if you want to call them that, or incriminating statements. So what the state of Indiana did is seriously inhumane, and a portion of me hopes that this is one of the appellate issues that is successful. And a selfish part of me would love to see this go all the way to the Supreme Court. But that's me being selfish because, I think there should be some U.S. law that really defines, what is inhumane treatment, what is torture when it comes to SDU units. Sorry, I got to mute my watch here. All right. So I'm going to get started here. Let's see. Okay. Just make this bigger, and I'm going to share my screen. Your resolution is to quit smoking cigarettes? That's good. That's a good one. Please don't switch over to the vape. It is so worse, and it's so much harder to stop. Like when I did smoke cigarettes, the good part is I never smoked in my house or my car, so I would have to go outside to smoke, and that really sucks in the winter really badly. So I didn't smoke as much as I believe I vape now. So, all right, share my screen. All right, let me switch back to make sure you all can see it. Okay, maybe I'm going to switch the view here. Not that view. Nope, definitely not that one either. This is a hot mess. Oh, goodness. All right, let's try this again. Sorry about that. Kind of switched up my StreamYard. All right, I'll just try to make it bigger here. Okay. So this is actually an 8th Amendment claim. I think it's an 8 and a 14th Amendment. So this Jay Vermillion is the plaintiff, and this was brought against these defendants. So these are all, I guess you would call them employees of Westville. And they have various titles, and there's titles, and a couple of these are ISP. And I'll just walk through it. Okay. I don't think I'm going to read everything. So the intro of this is an action. This action was transferred from the Northern District of Indiana to the district following the 7th Circuit mandate issued April 6, 2015. The mandate summarized Vermillion's claims as follows. Vermillion alleges that on July 29, 2009, he was interviewed by internal affairs investigators after several fellow inmates had escaped from the Indiana State Prison, ISP. The interviewers accused him of being involved in the escape and threatened to pursue criminal charges, prompting Vermillion to stop answering their questions. So he's basically inserting his right to not incriminate himself, right? Following this encounter, according to Vermillion, the 3 interviewers, along with another investigator from internal affairs. All right, I'm going to stop here. So what comes to mind when internal affairs is involved, right? To me, it's corruption or some type of investigation to make sure that policy and law has been followed within, the state. Okay, so I'm going to continue. And 5 administrators from ISP, Westville Correctional Facility, and DOC headquarters retaliated for his silence by immediately placing him in punitive segregation at ISP. And then on August 12th, 2009, transferring him to Westville, where he was housed in the maximum control unit or segregation unit. This transfer, Vermillion alleges, occurred after 2 of the administrators falsified documents to exaggerate his security classification. All 9 of these employees are named defendants. Okay. Ready for this part? This is shocking. So if that has not shocked you already, okay, there's more to it. It gets worse. Vermillion claims that for more than 3 years after the transfer, he was confined in his segregation cell at Westville for at least 23 hours per day without personal interaction with other inmates. And during those years, 5 of the same 9 employees, joined by many others, continued retaliating against him for invoking his right to remain silent. So he was exercising his Fifth Amendment right. This retaliation, Vermillion alleges, ranged from intercepting his mail and mishandling the administrative hearings concerning a disciplinary ticket for trafficking contraband. Mandate at Part 2. Vermillion argues that his transfer violated his right to due process, but also was initiated for the purpose of retaliating for his refusal to answer questions about the escaped prisoners. The Fifth Amendment gives a person the right not to answer official questions, but put to him in any other proceeding, civil or criminal, formal or informal, where the answers might incriminate him in future criminal proceedings. And then there's a case cited here from 1973. This right applies in the prison disciplinary context, and prison officials may violate a prisoner's right against self-incrimination if a prisoner's silence alone results in punishment of the kind capable of compelling waiver of the right. Some more case law here, if anyone wants to look it up. Although not all of his claims can be linked to his assertion of this right, Vermillion plausibly alleges that more than just the 5 administrators were involved in retaliating against him for his refusal to talk to internal affairs investigators. Vermillion claims that his placement in punitive segregation at ISP, his transfer to maximum control segregation unit at Westville, and the alleged falsification of documents to exaggerate his security classification and keep him confined in segregation were punishments aimed at retaliating against him because he asserted his right to silence. Because his claim points to joint conduct by 5 administrators and 4 internal affair investigators and would invariably rely on some of the same facts of his due process claim relating to the transfer, Vermillion properly joined the defendants allegedly responsible. Okay, so what is going on here is that there was an investigation and it originated at ISP, and he was transferred to Westville. And not only did, he went right into segregation, okay, because he refused to answer questions from internal affairs. And I'm going to get to the point where when I read it, I had to say it like 5 times because I couldn't believe it. But where I'm going with this is, do you see how like him not talking went in, like his punishment for not talking and asserting his Fifth Amendment rights led to, solitary confinement, not for 1 year, not for 2 years. How much was it? More than 3 years he was in the solitary confinement. Okay, I'm going to move on. Okay, so it's actually 1,513 days or more than 4 years. So more 1,513 days of being in solitary confinement. And the conditions here is outlined. Okay. Following the transfer of the action to this district, Vermillion was instructed to file a 3rd amended complaint. That pleading was screened and the following claims were permitted to proceed consistent with the mandate. Okay, so there's 4 claims here and many people involved, okay? So claim 1, and I'm probably going to botch the names here. So please forgive me. Willard Plank, Don Buss, Charles Whalen. I think I said that right. Whalen, yeah. Ralph Carrasco, Mark Levinghagen, Brett Mize, Howard Morton, Sally Nowitzki, and Gary Brennan. Placed Vermillion in punitive segregation at ISP, transferred him to the Maximum Control Segregation Unit, also known as the WCU at Westville, and confined him into segregation in retaliation for his assertion of his right to silence during an interview by internal affairs investigators. Claim 2, which has a lot of the other people listed above, if not all of them actually, placed Vermillion in the Westville Control Unit for 1,513 days in violation of his right to be free of cruel and unusual punishment. Claim 3 pretty much has everyone above. Probably dropped some of them. Transferred to Vermillion from the ISP to department-wide administrative segregation at the Westville Control Unit in violation of his due process rights. Claim 4. This is also crazy. Howard Morton confiscated Vermillion's certified legal mail in violation of his due process and First Amendment rights. The defendants seek summary judgment as a matter of law on all but the claim against Levinghagen and Mize, related to Vermillion's transfer from ISP to department-wide administrative segregation at Westville in violation of his due process rights. See Claim 3. The defendants argue that they are entitled to judgment as a matter of law as to all other claims. Given the age of this case and the number of claims, the defendants' and evidentiary record is relatively sparse. In support of summary judgment, the defendants present Vermillion's deposition, including 30 pages of exhibits, a 2-page declaration from Charles Whalen, and an audio recording of Vermillion's July 29, 2009 interview with internal affairs officers. So they have the recording. They got the recording of this interview when he was first being interrogated. And we're going to go into what he was being interrogated for in just a second. So Vermillion opposes summary judgment. In addition to his third amended complaint, which was signed under penalty of perjury, he presents 14 exhibits which all appear to be IDOC records. The defendants replied, and Vermillion submitted a surreply. I think I pronounced that right. The motion for summary judgment is now fully briefed. Okay, so then they go into here the summary judgment standard. Okay, this is a lot of legal jargon here. It's basically, setting the tone, as it's right here. It says Rule 56 makes it clear whether a party asserts that a fact is undisputed or generally disputed. The party must support the asserted fact by citing to particular parts of the record, including deposition documents or affidavits. So it's just basically like, what is the standard here? Okay, but I'm going to move on because that's like a lot of, like I said, legal jargon, and I don't think it's that relevant to what I want to talk about here, because he was successful in this case. All right. So I'm going to go to the, material facts, parties. Willard Plank was at all times relevant to the allegations made against him in the third amended complaint, an employee of Indiana Department of Correction, Division of Internal Affairs, as chief investigator. Other than his participation in the July 29, 2009 interview, Vermillion has no information regarding Plank's involvement in the circumstances at issue in this case. Dawn Buss, at all times relevant to the allegations made against her in the third amended complaint, an IDOC employee, Division of Internal Affairs by Deputy Chief. Other than her participation in the July 29, 2009 interview, Vermillion has no information regarding Dawn Buss's involvement in circumstances at the issue in this case. Okay, number 3. So they're really like walking through all the employees and whether or not they had, what was their role in this. So going on, Charles Whalen was at all times relevant to the allegations made against him in the third amendment complaint. Vermillion had no interaction with Charles Whalen other than the interview. And then Ralph Carrasco was all times relevant to the allegations. So this person here, I'll just read it. An employee of IDOC Division of Internal Affairs at ISP as Internal Affairs Officer. 4, Vermillion only support for a claim against Carrasco is that he prepared a conduct report charging Vermillion with a trafficking offense. So basically, there was trafficking involved, right? So I'm going to go on. Mark Levenhagen, or Hagen, was at all times relevant to the third amended complaint, employed by IDOC as a superintendent of Westville Correctional Facility. And then Brett Mies was the one who decided whether or not you are going to be placed in administrative segregation status. Howard Morton, at all relevant times to the third amendment complaint, was employed by IODC at ISP as administrative assistant. The Sally Chick, at all times relevant times to the third amendment complaint, was employed by IDOC at Westville as a counselor. She served as the case manager who worked in the WCU. Gary Brennan, at all relevant times of the third amendment complaint, was employed by the IDOC at Westville as an administrative assistant. Brennan was one of the officials who oversaw the WCU. Okay, so now it's going to get into the nuts and bolts of this case, okay? And what was being really investigated by Internal Affairs. So, investigation and transfer. On July 12, 2009, Offenders Lance Betriel, Charles Smith, and Mark Booher escaped from ISP, which is located in Michigan City, Indiana. So that's up north. Anyway, 2, during the course of the investigation into the escape, information was received from an offender that unit team counselor Don Bates and Vermillion were trafficking tobacco into ISP and that the proceeds were being stored in the law library. During a subsequent interview into the allegations of trafficking with offenders, Bates confessed to trafficking tobacco with Vermillion. Okay, so we have here an employee that admitted to trafficking tobacco, but names Vermillion as his accomplice. All right, 3, based on this information, investigators decided to interview Vermillion. 4, on July 29, 2009, Vermillion was taken from his cell at ISP to the Internal Affairs Office, where he was interviewed by IDOC Internal Affairs investigators Charles Whalen, Don Buss, and Willard Plank. The audio recording reviewed it by the court reflects that officers wanted Vermillion to assist with their investigation, and they suggest that if he cooperated, he might be permitted to keep his cat in lockup. Okay. I guess this was a manual filing audio recording at 4 minutes, 48 seconds. Vermillion then asked, why would I go to lockup? I think that's a reasonable question. Like, what are you talking about, Willis? Okay. Anyway, he is told for trafficking at 5 minutes and 32 seconds. One of the officers goes on to say that they spoke with Bates yesterday and that he doesn't work here any longer. So the dude lost his job. Vermillion asked what that has to do with him at 5 minutes and 41 seconds. The answer cannot be discerned from the audio, but the officer goes on to state that they would like Vermillion to assist them because he has a wealth of information you could help us with. That pertains to escape, to trafficking with Bates, cell phones, tobacco, 3 or 4 times a week. We have a general idea of what's going on, but we just want you to play ball with us. That's all. So this happens between 6 minutes, 4 seconds to 6 minutes, 24 seconds. Vermillion then told Plank, I don't think we have anything else to talk about. And then in response, Plank said, okay, lock him up. Doesn't this sound familiar? Okay. So now we're going to go into him going into the segregation unit, which is just mind-blowing also. Plank then explained that Vermillion would be placed in segregation pending the investigation, and the outcome would probably be a charge of trafficking with a staff member. Audio at 6 minutes and 52 seconds. In addition, if as a result of the investigation, it is determined that he was involved with the escape, he would be charged with aiding and abetting the escape. Audio at 7 minutes, 11 seconds. Plank then asked, you got any questions? Vermillion said no. Audio at 7 minutes and 22 seconds. Vermillion was handcuffed and taken from the interview to the disciplinary segregation unit, IDU. Okay. On July 31st, 2009, Internal Affairs investigator Ralph Carrasco prepared a conduct report charging Vermillion with trafficking with ISP counselor Don Bates. The conduct report provides in relevant part. Okay. So here's the date of the incident, July 29, 2009 at 9:30 a.m. This is very important because at this time, it couldn't have been possible that he was involved in this, and that comes out way later. So this is what they said the description of the incident is. On 7/29/09 at 9:30 a.m., during an interview with Counselor Donald Bates, Mr. Bates did admit to trafficking with the offender Vermillion number 973683, Mr. Bates stated that he trafficked into tobacco and a cell phone to Vermillion. Offender Vermillion was questioned on this and declined to make a statement. Okay. A few days later, a screening officer met with Vermillion and provided him with a screening report indicating that he was under investigation for trafficking with staff member. Vermillion was also provided a segregation confinement report, which informed him that he was being placed in segregation pending investigation for trafficking with staff. Prior to his confinement and segregation, Vermillion worked in the law library. Okay, so you see this connection? Because remember, they were talking about this. Following the internal affairs interview, a search of the law library uncovered $12,000 in cash and 4 pounds of tobacco. Okay, so if anyone knows anyone in prison, jail, or whatever, currency of cash is not a thing. Prisoners do not have cash. Cash is not valuable in prison. I'm talking about like paper currency. Like, that's not a thing. So why would, did you ever watch those movies where people are trading tobacco? Like, they exchange commissary, not money. So who do you think that money was for? And hence why internal affairs is involved. Trafficking in money and tobacco is a security risk to the orderly operation of a prison facility. Segregating an offender involving a trafficking is a means of disrupting a trafficking network. Whalen testified that Vermillion was placed in segregation pending the outcome of the investigation to trafficking, and not because he refused to answer questions during his interview. Any offender involved in trafficking would be placed in segregation, and Vermillion was not treated any differently. Vermillion was confined in the IDU from July 29 to August 12, 2009. On August 12, 2009, Vermillion was found guilty of trafficking and transferred from ISP to the Westville Control Unit, or WCU. He was sentenced to 1 year in disciplinary segregation, lost 30 days of good time, and was demoted from credit earning class 1 to credit earning class 2. Vermillion's trafficking conviction was vacated for rehearing 3 times. The Seventh Circuit's order, which remanded Vermillion's petition for a writ of habeas corpus in Vermillion versus Superintendent, was decided years after this civil rights action was initiated. That order discusses the fact that Vermillion was not given notice of the charge alleged against him. So, it's still, even though you're in like jail or prison, you still are afforded due process. You still, like, the 14th Amendment still comes into play. You know, all that stuff. And the 5th Amendment, all that is my understanding. On February 13, 2014, however, instead of conducting a 4th hearing of the trafficking charge, Vermillion's trafficking charge of July 29, 2009 was dismissed, and the entire matter was expunged from his record. So, like, he wasn't even, like, tried for this. It was dismissed. I think it was just dismissed. I'm not sure about the try, so scratch it. But it was dismissed. So at some point, they figured out, like, this dude was not even involved in this shit. Okay? So Vermillion repeatedly argues that he should never have been found guilty of trafficking because on July 29, 2009, he was being interviewed by Internal Affairs and not available for trafficking. There's no doubt the conduct report was flawed. The conduct report lists, for the date of the offense, the date when the prison counselor confessed that he and Vermillion trafficked. The Seventh Circuit noted that the only incident date appearing in this record is July 29th, and the prison does not contend that it ever believed that this date was correct. The conduct report does not reflect that on the date of time Vermillion was actively involved in trafficking. It is for this reason that the anticipated testimony of ISP officers Sabinski, McCormick and Walker, and ISP Disciplinary Hearing Board Chairman Bessie Leonard, is insufficient to create a material fact in disputes. Okay. So it ends here. I'm sorry. I was like going on. I was reading the other paragraph. But look at the sentence of this paragraph. There is no dispute that Vermillion was not trafficking on July 29, 2009. That's like a double negative. Anyway, on or about August 12, 2009, WCU case counselor Sally Nowatsky, probably botching that name, and WCU Director of Operations Gary Brennan, I don't know if there's any relation there, falsified information and documentation to increase Vermillion's security classification designation so that he could be housed at the Supermax facility. So they falsified documents so he could be classified to go there just because he wouldn't talk. Vermillion testified that from August 12, 2009, he was placed in the C-pod where psychotic, out of control, and unmanageable inmates are housed. For the next 3.5 years, he was subjected to the following conditions. A, incomplete isolation in a solid concrete cell with a solid steel door for 23 to 24 hours a day. B, no direct contact or interaction with others. C, extreme cold. D, constant strobe lighting. E, self-flooding. F, mace fumes. G, people threatening to and actually committing suicide. H, no actual recreation. I, no telephone use for 2.5 years of the 4+ years. No work. J, no work, income, or educational opportunities. K, no religious services. L, no hot water. M, cold meals. N, regular cell ransacking. And O, humiliating strip searches. And so, like, one of the main reasons why I wanted to cover this case here, or this example, is there's a clear outline here of the conditions of this housing unit, okay? Which is very similar to what I read as to the conditions of Richard Allen. Kind of sets the tone of Westville. I'm wondering why there's strobe lights. All right, anyway. In October of 2009, Vermillion met with Doug Barnes, who informed him that he was placed on department-wide administrative segregation per Brett Mize. Howard Motion's only involved in this lawsuit was in regard to Vermillion's legal mail. Vermillion wrote letters and hand-drafted affidavits for Sergeant Sabinski, Officer Springfield, and Officer Day. Vermillion wanted the sergeant and officers to sign affidavits in support of his appeal from his prison disciplinary conviction for trafficking. Howard Morton sent Vermillion 2 letters informing Vermillion that he received the letters and that IDOC staff would not be signing affidavits for Vermillion. Sergeant Sabinski, Officer Springfield, and Officer Day were not Vermillion's attorneys, but were employees of the Indiana Department of Corrections. The letters reflect the following. So it's basically, this is to acknowledge receipt of your correspondence to Sergeant Day and Officer Springfield. After checking with DOC Legal, staff will not be signing any affidavit for you. I'm returning all documents you have sent to the Indiana State Prison regarding this issue. So they all got the same type of language in there. This letter was located in Vermillion versus Superintendent, so there's another cause here. 20, Vermillion is now back in general population. 21, pending 1,513 days on an, what is it, ergonomically incorrect mat in a painfully cold cell and without access to a chair caused Vermillion spinal problems. In addition, being placed in solitary confinement under harsh conditions without due process and based on a conduct report that was ultimately expunged caused him mental, emotional, and psychological injury. Okay. So now this kind of goes into retaliation. Vermillion's first claim that William Plank, Don Buss, Charles Whalen, Ralph Carrasco, Mark Levenhagen, Brett Mize, Howard Morton, Sally Noetsky, and Gary Brennan placed Vermillion in punitive segregation at ISP, transferred him to the Maximum Control Segregation Unit, the ICU, in Westville, and confined him in segregation in retaliation for his assertion of his right to silence during an interview by internal affairs investigators. For the reasons explained below, the defendants are entitled for summary judgment on this claim. I'm going to put the link of this case. I could read and read and read, but basically, this guy was he was awarded over $500,000 for this. I don't even think that's enough, to tell you the truth. It's crazy. I'm lost for words. I really am. It's like, why is it the prisoner's problem that you have corruption in your own facility? Like, why don't you clean your, check your backyard first? I'm going to catch up with comments. Hey, Criminal Network. Oh, don't worry, V. Okay. I think you might have figured it out by now, but so I'm going over Richard Allen's conditions and the brief today, but I thought I'd set the tone as to what Westville is known to, of based on other, claims, Eighth Amendment claims and violations of due process, which I believe we see here in this case. But this poor man spent years in segregation. I don't even know how that guy's sane right now, but that's Westville for you, and that's ISP for you. Oh, Shibby's live. Oh, thank you, Heather. B, I can't hear. I got two voices. Are you doing a Shibby thing where you got two live streams going on in your earbuds? And so is he. You guys are hilarious. Like, you totally, it's fine. If you want to go over there, I'm kind of like messing up with his time. I just wanted to get this out. People can watch it on the replay. No offense, whatever. So anyhow, I won't be upset. But your multitask skills are on point. Oh, here he is. Hi. I'm way behind though. Oh no, actually I'm not that bad. Okay, good. You figured it out. Oh. Yeah, I can't do that. I can hardly work and listen to music. V, did you have a nice Christmas? All right. So I'm going to now go on to something else real quick, and then I'll get to the brief. Okay. So there was a, oh shoot, I didn't share my screen. Okay. So this was a settlement that occurred in 2016-ish. Because of the conditions in solitary confinement, the ACL had sued the Department of Corrections on behalf of many, many different plaintiffs. And unfortunately, the settlement, which laid out the best practices, I guess we could call it, of what is, what people with mental illnesses should, be treated. Well, that settlement, it's my understanding, it was only a certain time period. It expired by the time Richard Allen was a safekeeper. But anyway, I'm going to read this real quick. It's very brief. The ACLU of Indiana, Indiana Protection and Advocacy Services, and Indiana Department of Corrections have reached an agreement on how to treat mentally ill prisoners years after a judge attributed a number of suicides to poor treatment in Indiana prisons. Between 2007 and 2011, IDOC saw 23 suicides in its facilities. 11 of these occurred in solitary confinement in a lawsuit brought by the ACLU. And I don't know if it's pronounced that way, but anyway, a judge found that the treatment of mentally ill prisoners, isolating them for 23 hours a day, violated Eighth Amendment protections against cruel and unusual punishments. But according to the ACLU and IPAS, IDOC has done a lot to make things better since that lawsuit. For one thing, it's a lot harder to put mentally ill prisoners in solitary. And those prisoners actually get therapy. Wow. A lot harder to put mentally ill prisoners in solitary. And here's the thing with this. It's like, what's his name? Galapo. I don't know how to pronounce that jerk's name. Gallipo. I think that's how it is. It's like, sorry, where was I going with this? There's a lot of lawsuits against him, and the instructions from the central office of IDOC were from day one to put Richard Allen in a suicide room. So I think there's only 2 or 4 of them, one per pod, with a camera on him 24/7, 24 hours, 7 days a week. That was from day one. So he's inconsistent how he was answering that in the depositions. First he was lying about shit too, where he was saying, oh, that the video cameras didn't have audio, which is like, turned out they did. But those were his instructions from like day one. So I feel like either you classified him as mentally ill or you were violating his rights, in my opinion. Like, he is not being treated. If we even go by the same standard here as to how you're supposed to treat pretrial detainees or offenders or convicted, felons, he was treated differently even from other convicted felons or, offenders. Because there's only one camera in each pod, you know what I'm saying? And he was treated differently. So, but that just really gets me, is like the settlement ended right around the same time of his safekeeping. And so instead of them just saying, hey, let's do the right thing and treat people with mental illnesses the right way and the humane way, they just said, oh, we don't have to do the settlement anymore. It's ridiculous. All right. You guys probably can't read that. That's like really tiny. Sorry, I'm glad I'm reading it out loud. All right. So here's another article about it. We switch screens. I should just share my whole tab. Sorry about that. Okay. Oh, this is back about the Vermilion article, actually. Yeah, 425,000. Okay. Sorry. A little off, a little all over the place right now. I clicked on the wrong tab. Okay, here it is. So deal would ban solitary for some Indiana inmates. Indianapolis. So this was an article posted January 28, 2016. Says the ACLU proposed a settlement Thursday in its case against the Indiana Department of Corrections. The agreement would bar Indiana's prisons for putting inmates with serious mental illnesses in solitary confinement with no access to treatment. So they weren't even getting treatment at some point. So that's a part of the lawsuit. Okay. The Indiana DOC estimates that more than 5,600 inmates are considered seriously mentally ill. The ACLU says the Department of Corrections have already improved conditions for special need inmates at a number of correctional facilities. If a judge approves the proposal, it would settle a lawsuit with ACLU filed in 2008, accusing the DOC of violating mentally ill inmates' constitutional rights. So, there's a video here. It goes into a little bit more detail on that. Okay. Here's another one. I'm not going to share my screen, but I'll just read it. It says, no mentally ill inmate will be placed in solitary confinement for more than 30 days, according to a settlement between the American Civil Liberties Union, Indiana Protection and Advocacy Services, and Department of Corrections. In addition, inmates will receive individual and group counseling as well as more recreational opportunities. In 2008, the American Civil Liberties Union filed a lawsuit against the Indiana Department of Corrections for its excessive use of solitary confinement for mentally ill prisoners. Segregation, not surprisingly, is toxic, particularly for those who are mentally ill, said ACLU Indiana Legal Director Ken Falk. There were a lot of prisoners in there for punishment because they had misbehaved because of their mental illness. With 5,600 mentally ill inmates, the Indiana Department of Correction houses more people with psychiatric problems than all other facilities across the state combined. The Marion County Jail is the leading mental health facility in Indianapolis, with almost 900 offenders on daily medication. These are all prisoners who will be getting out. It is society's advantage, all of our advantage, to treat their mental illness the best we can in prison, said Falk about the DOC settlement. Falk said a new 250-bed facility for the mentally ill at Pendleton Correctional Facility is evidence of DOC's shift towards better strategies, policies, and treatments of offenders suffering from mental illness. Wow, would you look at that? There is a facility, as of like 2016 that deals with offenders suffering from mental illness. Even though Richard Allen wasn't considered an offender back then, he was a safekeeper and he was in custody of the DOC. Okay. The ACLU and advocacy groups will continue to monitor the system for 3 years, right? So it was like a 3-year thing or settlement where they would have audits and making sure that they're following along with the guidance and what they agreed to. All right, moving on. Last week, the ACLU settled another lawsuit against the Pennsylvania Department of Health for long wait times for inmates to be transferred to a psychiatric hospital after being found incompetent to stand trial. As awareness and outrage about the criminalization of mental illness across the country continues to grow, we expect to have a wave of states settle similar lawsuits in the future. We commend the ACLU for bringing these lawsuits against the state prison systems for the deplorable way our criminal justice system handles people with mental illness. But the problem remains. If we really want to get serious about reducing solitary confinement, we should ensure that people who enter jail receive the treatment they need when they need it. In its current state, the American prison system is incapable of adequately meeting the mental health needs of its inmates. And then there's the Treatment Advocacy Center report here from 2014. I'm going to put the link in here, actually. Okay. Then, so if I went through IDOC's policy, so they have, policies and procedures to, when it comes to classifying offenders, inmates, where they should go, it outlines safekeepers, where safekeepers should go. And it specifically states that safekeepers should be housed in the least restrictive environment. So putting Richard Allen immediately, if we want to go with he's not considered mentally ill, to a maximum security prison, and not only a maximum security prison, but also a prison, like the least restrictive environment for such maximum security prison is contrary to what their policy states. And furthermore, the policy states that people that are gravely mentally ill do not go to, I think it's Pendleton or Newcastle is where they would go if they are classified a certain manner. So if there's enough time, if I don't put everyone to sleep, I could pull it up because it's all in there. It's in their policy. So why was Richard Allen treated differently? And I really hate the argument that there was other safekeepers. There's other safekeepers. It is like the worst fucking argument ever to make, because actually in 2022, I pulled up a report and there's only Richard Allen was one of 2 safekeepers in the whole entire state of Indiana. So yes, while they do have safekeepers, it's very uncommon. To me, a better, means to handle the situation would have been Carroll County. I don't know how many cells they have, but I know it's a very small prison. Why don't you just keep Richard Allen in that prison only and transfer all the other people that are being picked up and being detained until they make bond or whatever to White County or Lafayette or Tippecanoe or whatever. Or how about you create a system for this type of scenario that doesn't entail being put in a maximum security prison in the least restrictive environment and torture a man for over a year. So I really, really hate that argument. Just saying. Hey, HCC, how you doing? What, did you have to subscribe? I don't think I put a time limit on it. Nice to see you. All right, so let's move on to the brief. All right, I'm going to have to share it as a PDF, I think. gosh. Mm-hmm. All right. Okay. I swear, y'all, I do not have this problem at work sharing screens. I share screens all the time. Okay, here it is. All right. Can y'all see it? Okay. So what I did is I skipped to, you know what? Okay, it's good. I went down to page 67, which is really where it starts talking about the treatments of the pretrial solitary confinement. So, okay. The trial court erred by omitting statements Allen made while gravely disabled during the unprecedented pretrial solitary confinement in a maximum security prison. And then there's a quote, I found solitary confinement the most forbidding aspect of prison life. There is no end and no beginning. There's only one mind, which can begin to play tricks. Was that a dream or did it really happen? One begins to question everything. Nelson Mandela. So that's a pretty strong quote. I love quotes. All right. Solitary confinement is a form of punishment, and depending on its condition, even torture. By 2023, when Allen was held in solitary for 13 months, it was well established that prolonged isolation caused psychological pain, suicidal ideation, and psychosis. To protect inmates from psychological harm, the IDOC strictly prohibits solitary confinement over 30 days for anyone with serious mental illness and requires transfer if SMI symptoms appear. When Allen exhibited the predictable symptoms of psychological pain, confusion, and psychosis, IDOC administrators refused to transfer him to a mental health unit. When Allen's attorneys informed the court of his dire condition, the court also refused to move him. And the prosecutor delayed and mocked counsel's concerns while collecting evidence of Allen's confessions. That is like very true. I mean, how many motions were there to modify the safekeeping? It was, two hearings. And Gall was just like laughing and mocking them, laughing at them, mocking them. And if I'm not correct, stated, it sounds like it's more of a logistical convenience for you. Like, what the fuck? And then it ends up to be everything that they said it was. And they modified it. And guess what? They were able to house him in a non-maximum security prison. Isn't that interesting? They were able to treat him, house him, keep him safe outside of a solitary confinement in a maximum security with horrendous conditions. Isn't that interesting? Oh, wait, I know why. Because they've already got confessions from him. So, anyhow. All right, going on. The question for this court is unprecedented but simple. Should the state be able to benefit from Allen's psychological pain and that the deliberate indifference to his mental health costs? Human decency provides the answer. No. A standard of review and additional facts. An appellate court reviews a suppression denial for substantial evidence of probative value that supports a trial court's decision. State versus Benzuli. This is a 2011 case in the Northeastern 2nd District. I'm saying that right. It considers uncontradicted evidence. Okay, Ellen's brief, favorable to the defendant and reviews legal issues de novo. So, like, my understanding de novo is like they just look at everything without a hearing. I think that's what that is. Okay. The voluntariness of a confession is a legal issue. Allen moved to suppress his statements made while in solitary confinement, which the court denied. And then they're citing the appendix, volume 7, I think. Okay. The court reasoned the statements were voluntary because Allen failed to show they resulted from state psychological coercion or coercive interrogation. The court finds Allen's detention was intended to protect him, and that while he suffered from major depressive disorder, MDD, and anxiety, he did not have SMI that would render his statements involuntary. In addition to IDOC's records and videos like those admitted at trial, Allen proffered an order and settlement from Indiana Protection Advocacy, IPAS, versus IDOC that the trial court excluded from the suppression hearing as irrelevant. So I think that's that one case that I was just talking about, if I'm not mistaken, that settlement and the rules that was within that settlement that pretty much expired. In 2011, the Southern District of Indiana held that IDOC's housing of SMI inmates in solitary constituted cruel and unusual punishment, violating the Eighth Amendment. The Southern District found SMI includes delusional disorder, psychiatric or psychotic disorder, and MDD. Segregation is harmful to prisoners with SMI due to lack of social interaction, significant sensory deprivation, and forced idleness, leading to decompensation and psychological pain. An inmate decompensating, oh my God, I'm horrible, from solitary may experience hallucinations, sleep disturbance, memory problems, anxiety, paranoia, depression, eating problems, or engaging in self-injury or suicide. Suicide watch further exacerbates the illness. So when I was talking in the beginning about the SDU, what is it called? Illness, it's a thing. Like, it's been studied, and a lot of the things that Richard Allen was doing and you know, some of these experiences in solitary confinement is consistent with the study, and it's been studied for many, many, many years. I mean, like, people want to make fun of him and his feces thing. That is not a new thing. That is actually somebody that suffers from SDU syndrome. That's what it's called. Okay. The severe conditions in segregation units causes a predictable deterioration of SMI prisoners' mental health, and the IDOC has explicitly observed, diagnosed, and noted patient decompensation. The IDOC knew these efforts occurred even in non-SMI offenders. Yep. Before a hearing on relief, the parties reached a settlement including an expanded definition of SMI that subsumed the court's definition. I'm sorry, I'm like losing my voice already. It's crazy. The IDOC's policy referred to the settlement, which sets the policy's tone. An inmate with SMI can only be held in solitary for 30 days. If an inmate decompensates into SMI and is unlikely to return to general population with 30 days, transfer is required. Like, hello? See, all y'all are getting this raw from me because, like, I did not read this whole thing. You're going to get raw reactions here. So, yeah, like, common sense, right? I mean, if you're anywhere for 30 days and you're not, like, getting better, usually that, you know, that is a natural thought. Oh, shit, maybe I need to go somewhere else to get better. Allen admitted Dr. Westcott's 127-page report on August 21st, 2023. Westcott evaluate Allen, who had been in WCU for over 9 months. Like, people have made humans in 9 months. Like, that's a long time. Just saying. He was terrified, unsure what was real, and was wondering if he was dead in hell. Well, you were in hell, or waiting for heaven. He could not recall weeks of early 2023, including playing with feces, confessing, or banging his head. He believed that he had been drugged. Yeah, like, okay, voila. He's manifesting. Get the fuck out of here. Sorry. Okay. Westcott cited IDOC records showing acute periods of confusion, paranoia, delusional thinking, cognitive slowing, aggression, and combativeness. During this period of loss of touch with reality, Allen confessed, just like they wanted. Westcott concluded Allen's psychosis stemmed from MDD, his personality, and the well-known effects of solitary confinement. Allen was grossly disorganized, delusional, and paranoid. Objective testing ruled out malingering. Yeah, voila. Okay. B, the trial court abused its discretion by refusing to admit the IPAS order settlement into suppression hearing. Evidence is relevant if it has any tendency to make a fact, consequence, in determining the action more or less probable than it would be without it. Indiana Rule of Evidence 401. Here, the order of settlement makes it more likely Allen's psychosis was caused by his confinement. The order found solitary confinement causes all these symptoms Allen experienced. Allen was more likely to decompensate because he spent 7 months on suicide watch and even more restrictive form of solitary. So solitary is not enough, right? I mean, there's even a more restrictive form. Do you see this? Sorry. It's just sorry, but not sorry. That's crazy. So they had, like, those suicide companions that, were there to, make sure he doesn't harm himself, but somehow he's, ends up banging his head on the wall for a long time, and didn't prevent him from that. Neither did the state actors sitting outside the door. The order settlement also makes it likely Allen was subjected to psychological coercion by showing solitary causes psychological pain. It demonstrates state action. The IDOC placing and keeping Allen in solitary, knowing it was causing this predictable pain. Yeah, absolutely. It's like a wanton disregard. It's like, who's gross negligent now? The order settlement shows how extensively IDOC violated its own policy, and it includes MDD in the SMI definition, restricting Allen's solitary to 30 days. Allen was harmed by the court's refusal to consider the order settlement because it undermined the court's findings and conclusions. C, the state failed to prove Allen's statements made while gravely disabled were voluntary. 1, the U.S. Constitution, the state failed to prove that Allen's statements were not a product of psychological coercion. An involuntary statement obtained through state action violates due process and is inadmissible. Colorado v. Connolly, I guess, a 1986 case. A confession is voluntary if it is a product of rational intellect and freely self-determined rather than overborne will by state law enforcement conduct. Yeah, this is like, okay, what is state law enforcement conduct? I have to vape. I'm really pissed. Rogers v. Richmond. State law enforcement can include psychiatric facilities and prison staff. Townsend v. Henderson. Yes, I did look into that case, that Townsend v. Henderson, when I was like trying to figure out what the fuck was going on. Statements produced through a coercive environment are involuntary, regardless of whether solicited through police interrogation. Yes, absolutely. Like, it doesn't have to be a person, like, directly. It could be indirect, like an environment could be coercion. United States v. Cherokee, months spent in solitary confinement, deprived of light, adequate, full, and contact with the outside world is by itself sufficient to sustain a finding of involuntariness. The crucial element is police overreaching. Connolly. That's a popular case, I think. When state actors use more subtle forms of psychological coercion, the defendant's mental illness is more significant in the voluntariness determination. Spano v. New York. I'm not aware of that one. That's an old case, 1959. Okay. But the state must still exploit the defendant's illness with coercion tactics. Connolly. This is generally done through aggressive interrogation, but exploitation can occur in other ways. This is the Townsend v. Sane. It is difficult to imagine a situation in which confession would be less the product of a free intellect, less voluntary, than when brought about a drug having the effect of truth serum. Yes, so there was this, pause. There was this case in actually Illinois that I was looking into where somebody, like the police, there was like a robbery or something, and they gave this guy truth serum, and he actually won. Like it was overturned. I forgot the case name, but it's really an interesting read. Contrary to the court's finding that Allen, I'm going to go back. A, the state prolonged solitary confinement of Allen was state action. Contrary to the court's finding that Allen failed to prove state psychological coercion, it was the state's burden to prove Allen's statement voluntary by preponderance of the evidence. Which one was overruled on the grounds by Keeney for? Oh, this is the truth serum one. Okay. To the extent Allen had minimal burden of production, he met that. Prolonged maximum security solitary confinement of a pretrial detainee, especially after psychosis develops, is state action. Yes, it is. Unlike the mentally ill defendant in Connolly, who walked into a police station and confessed, Allen never voluntarily came into custody. He consistently protests innocent until enduring 5 months of maximum security solitary with no human contact except while chained or caged. Yeah, I think just to provide additional insight, I'm wondering when Allen was asking for, where's the warden? Where is the chaplain? It's because he wanted human contact, especially with Dr. Walla. So I don't understand how the malingering works for the state. Why could it not work in Richard Allen's, defense? You know what I mean? He says already to Kathy Allen, I will tell them what they want to hear if it gets too rough for you. What makes us think that he wasn't doing that anyway? I know that he was not mentally correct, but could some of that been going on too? I don't know. Okay. Because it was pre-trial, Allen's solitary was unprecedented and borderline, if not unconstitutional punishment. Here's another case. Littlefield v. Thielen. Other IDOC safekeepers were in mental health units, not solitary. On a continuum of possible punishments in the justice system, solitary confinement in a maximum security facility is the most extreme. Yeah, that's quite different than least restrictive environment, don't you think? Also, Allen Solitary exceeded the 30-day IDOC policy restriction. It's in there. When IDOC observed Allen's predictable deterioration, they refused to transfer him. Keeping Allen in solitary when he was no doubt SMI was an administrative, not clinical decision. I'm curious about that because the administrative process is the classification, right? So to me, this reads like clinical decision did not lead to the correct classification. Does that make sense? That's just my perception of this, the language here and what I've looked into within the policy. Okay. Finally, the state's conduct also involved the prosecutor, law enforcement, and the court. After Allen filed his April 5th emergency transfer motion citing his dire condition, the prosecutor waited 9 days to respond while investigators monitored real-time calls in which Allen confessed. Wow. During this delay, Allen continued deteriorating. The prosecutor then mocked defense concerns as colorful and dramatic. While the same day, IDOC found Allen gravely disabled. Asshole. Knowing Allen was decompensating. Yeah, I just said decompensating. The court refused to transfer him, putting his onus on IDOC to provide care. It is fundamentally wrong to keep a gravely disabled Allen in solitary while using against him statements made to psychologists and suicide companions. Sims versus the state. Okay. 1 week later, the prosecutor sought all medical records, videos, and communications while confessions were ongoing. Monitoring and collecting his statements consumed hundreds of hours and produced over 60 confessions. ISP interviewed inmates and guards and even sent a psychologist to speak with Dr. Walla. Wow. Allen showed more than sufficient state action. B, the state prolonged pretrial solitary confinement was psychological coercion. I think it was collusion too. Allen's solitary was psychological coercion because it was prolonged, caused psychological pain, and put him at the mercy of the state. The prolonged nature of coercion, because solitary confinement can bring a person to the edge of madness, perhaps to madness itself. Davis v. Ayala. This has been recognized in literature, law, and science. Yeah, it's science, definitely. Oh, look, they cited A Tale of Two Cities. Okay. 170, what is that? A continuation. In re medley, 170. And was that? I heard law people talk about this. Grazian. Psychiatric effects of solitary confinement. 22 Wash. Solitary causes psychological trauma, including psychosis, hallucination, and paranoia. Yeah, this is a popular case. It's William v. I don't know what this Pennsylvania Department of Correction. I think like the Pennsylvania was like one of the big lawsuits, if I'm not mistaken, on this topic, where they like changed law. IDOC knew this. Yeah, because I bet you it was part of that whole what's it called? It was probably part of that whole settlement. Because when I was looking at the settlement, look at that link I put it in here earlier. Like that link is a study that was mentioned in it. It's probably this. Okay, from day one at WCU, Allen was placed in a strip cell. the most restrictive cell and the most restrictive solitary unit. I mean, like, what could be more confined than this? Like, this is like, I keep on saying this, but like, I mean, he's like one away from just being shackled to the wall. I mean, like, I guess that would be the most restrictive at this point. Just shackle him to a wall 24/7. With only bare essentials and a camera constantly recording him. Soon thereafter, IDOC ordered guards to videotape him when out of his cell, including showering and attorney visits. Suicide companions remain outside his door, documenting everything, regardless of suicide watch status. He had no contact with anyone unless caged or chained. The sensory deprivation, social isolation, and forced idleness is difficult even for healthy people. Memory distrust syndrome, confabulation, and false confession. Cortex 87. A healthy man wrongly implicated and detained in solitary questioned his memory and suspected he committed the crime, though he stayed sane by reading, exercising, and praying. The experience traumatized him. Earlier videos show Alan pacing his 8.5 by 12.5 cell. I think that's like the bare minimum dimensions, if I'm not mistaken. Laying down, doing leg crunches, writing, reading, and looking distressed. Cell videos, December through March, within 2 weeks. Alan said he was broken and told his wife, if this becomes too much for you, call the detectives and I will tell them what they want to know. I don't do what? Tell them whatever they want to know. Isn't it? Tell them whatever they want to hear. Okay, I'm moving on. Had Alan's solitary been 30 or even 90 days, he would not have decompensated, but it was 13 months. The prolonged solitary caused Alan's predictable psychological pain, paranoia, nightmares, memory problems, and confusion. It is undisputed Alan deteriorated to being gravely disabled and very psychotic, and the IDOC involuntary administered antipsychotics between April and late June. Although Satan noted concerns about, was it Fingning? She diagnosed psychosis and suspected incompetence and over-medication. You think? And WCU only mentioned Alan's mental health. Talking with a psychologist while shackled in a cage is not treatment. Solitary put Alan in a constant state of vulnerability. Solitary confinement has long been recognized as psychologically coercive, equated to the rack and thumb screw and protracted questioning. Pretrial solitary is punishment already underway and conveys without the necessity, I was right. Without the necessity of spoken words that implied threat of further punishment. Townsend v. Henderson, Sixth Circuit, 1968. It does not matter why a defendant was in solitary, whether justified or whether the person planned further punishment. Donnell v. Myers, Brooks v. Florida, U.S. v. Koch, I don't know. Stidham v. Swenson, Arnett v. Lewis. In this harsh environment, Satan controlled all aspects of Alan's life, including whether he got bedding, clothes, meal items, books, personal items, and utensils. She could provide a new window and a tablet or strip him to bare necessities. Privileges were contingent on pleasing her. Whether Satan had ill intent is irrelevant. It is what Alan thought and what solitary confinement did to him or would do to many of us. After confessing to Satan on May 3rd, he asked for his property back, and she indicated she needed more consistency. 1 second. Wow. May 3rd. Huh. May 3rd. So basically, his incentive was to give her more and more information to get his property back, which I think includes his tablet, because I've seen that being mentioned in conversations. Senator McCain, a prison camp survivor, explained solitary crushes your spirit and weakens your resistance more effectively than any other form of mistreatment. Alan entered solitary confinement compromised. He left broken. C. Alan's confessions were a product of solitary-induced psychosis, not rational intellect. IDOC records show that Alan continued to suffer from psychotic during the times he confessed. On April 5th, when he confessed to Dr. Walla, he was not eating or sleeping and was drinking from the toilet. On May 3rd, when he confessed, Alan had symptoms of paranoia and disorientation. Despite Satan claiming he presented as more organized than he has been, this day before he was confusing nightmares with reality and claiming to have started World War III. 2 days before, he was too disjointed to hold a conversation. 132 days earlier, he covered himself in feces and claimed he was King Michael. Was there a King Michael? Exhibit DDD. His confessions to guards occurred during bizarre and psychotic behavior. Guards believed he was faking, but they were not clinicians. And Dr. Westcott found no malingering through objective testing. Alan confessed to his family on April 3rd, May 10th, May 17th, May 25, and June 11th. So I'm just pause here. So I'm trying to recall what the confession was on April 3rd, because it wasn't until May 3rd, it seems like they got the confession that they were probably looking for. So was April 3rd vague? Was that the one with Kathy Allen? Where it's like, I'll tell you what you want to hear, or tell them what they want to hear, or something like that. I'm just trying to go off of memory here. Okay. Alan confessed to his family. I should just read the next paragraph. It's right in there, I mean. Okay, April 3rd, May 10th, May 17th, May 25th, and June 11th. On April 3rd, he also fell on the floor as if he was dead and was suicidal. On May 10th, he believed he was dead and that the world would blow up if he slept. His water was poisoned, and he was reliving the same day. Yeah, I'm sure like every day felt like the same day. And I heard a lot of shit about, like, when I was going through court cases, that there was issues with the water at Westville, like legitimate health issues with water. Oh my gosh, that is crazy. That was one of my theories, was the water. Not saying it was poison, but there was big issues with the water, like unsanitary water. Okay, moving on. On May 17th, he was paranoid of attorneys and staff with Odin patches. On May 25th, Alan paced for 2 hours and banged his head. On June 11th, he thought he was in hell, which he was, and did not, because Satan was there, and did not understand what was happening. In August, Alan did not remember confessing or weeks of early April. Throughout, he complained of memory loss. State action overbore Alan's will. Alan did not confess until after 5 to 7 months of solitary. Before arrest, he consistently denied involvement. Dr. Westcott opined Alan's psychosis was caused by the stress of solitary confinement on pre-existing illness. Satan agreed that a lot of time solitary confinement exacerbates mental illness, and it is reasonable to believe Alan's confinement caused his psychosis. The social isolation of solitary makes people question their self. Williams. If you are treated like you are guilty, you begin to think you are. Dr. Grazian, I was there when I saw his testimony, actually, testified a false memory starts with the belief. Yes, he did say that. He was a really good witness, by the way. Really good. And definitely, I think he was taught at Harvard or something. If I recall that correctly. Okay. In his first confession to his wife, Alan said, "I think I did it." In his first confession to Satan, he was unsure if he had sex with the girls. Alan got facts wrong and confessed to crimes he did not commit. Alan claimed he shot the girl. To Indiana Constitution, the state failed to prove Alan's statements were a product of rational intellect rather than the state's misconduct. The Indiana Constitution also protects against the omission of involuntary statements. Indiana's test is like the due process standard, requiring a confession be freely self-determined by a rational intellect and free will. Robbins v. State. However, it is more robust because it requires the state to prove voluntariness beyond a reasonable doubt. Pruitt. Also, it does not require state action to be coercive to overcome a mentally ill person's will. So I guess what they're saying is even like the standard doesn't even require coercion, coercive tactics, I guess. State v. Banks. Mentally ill defendant's statement involuntary due his altered state and confusion, although officers neither coerced him nor knew of his illness. The mental illness alone will not render a statement involuntary. There must be some state negligence. Ooh, look at the word negligence, huh? Okay. That's it. Sorry, I'm like abandoning the chat here because I'm on a roll here. But Tilted Kilt, that is a great comment. Haldol, is it antipsychotic medication? Why would you give it to somebody or someone who wasn't suffering from psychosis? Exactly. And why would you give it like an abundance amount of times? Okay. Here, the IDOC refusal to apply the 30-day policy to Alan and to transfer him after he deteriorated is at minimum negligent state conduct that caused Alan's psychosis and confessions, and the prosecutor's delay and the trial court's refusal to set a timely hearing exacerbated the deterioration. This conduct that our Constitution cannot tolerate, regardless of whether it constitutes coercion under federal due process. Also, the evidence does not show the statements were a product of rational intellect beyond a reasonable doubt. Allen was considered gravely disabled through June 16th, when he received his last emergency injection due to self-harm. Though Wallace sometimes described Allen as more coherent on his symptoms, not significant. The state cannot have it both ways. Oh my God, that's what I said. Sorry. Allen decompensated to the point of forced medication, but remained rational beyond a reasonable doubt. Even if Allen could occasionally hold a conversation, it does not render his confusion voluntary. D, even if the court finds Allen's statement voluntary, they are the product of unconstitutional detention. 1. Allen's prolonged solitary confinement violated Article 1, 12, and 15. Indiana courts are constitutionally bound by the basic concepts of fairness that are frequently identified with due process in the federal Constitution. Sanchez v. State, 2001 case, guarantees every person for every injury done to him in his person. Remedy by due course of law. Indiana Constitution, Article 1, Section 12. Here, Allen was sent to solitary for safekeeping. I love how they quoted this. Without even a hearing or notice. Even when his attorneys informed the court of his dire condition, the court refused to set a hearing in violation of Indiana Code 3533.11.2. It was Appendix 2, 244. Although the court, or that, yeah, I think it's appendix. Although the court eventually held a hearing on June 15, 2023, by that time the damage was done. Fairness protections in criminal cases are found in different Indiana constitutional provisions. McIntosh v. Melrose Company, is it? Indiana 2000. Just as pretrial punishment violates federal due process, it violates the Indiana Constitution. Indiana is one of just 6 states protecting citizens from unnecessary rigor. The framers wrote, no person arrested or confined in jail shall be treated with unnecessary rigor. Typically, this provision requires a prisoner suffers severe mistreatment. Kelly v. State. Well, it's a new one, huh? 2025. Sorry. Recognizing this provision applies to solitary confinement, the Indiana Supreme Court stated, the very essence of punishment and the sole use of the prison walls is the confinement of the convict within them. Humanity indeed forbids, as unnecessary rigor, that his confinement should be absolutely solitary, or that all of his natural and civil rights should be temporarily, annihilated. Helton v. Miller, emphasis added. Well, it's like pre-Civil War. Here, Allen's treatment rose to the level of unnecessary rigor. Rigor is the act of instance of strictness, severity, or cruelty. When Allen started suffering from confusion, memory lapse, paranoia, and bizarre behaviors, there was no longer a risk he could not handle the harsh conditions of maximum security solitary. It was a reality. The strictness, severity, and cruelty of his confinement is evident on video, where he is screaming in fear, confused about where he is, unable to respond, and drooling and self-harming. The rigor was physical too. William, solitary can result in physical harm, including self-mutilation. I can't say this. It's like a word I have to say without thinking about saying it. Mutilation. As a oh my God, I don't even know this word. I'm sorry. Maladaptive coping behavior. Allen lost 40 pounds, was unable to care for himself, was tased. Yeah, because he wouldn't get his hands out of the cup hole. Like, what damage is that doing to the guards? Freaking assholes. His face was black and blue and at times bleeding, and he was poisoned by fecal matter and toilet water. Indifference to his catotina is shown where medical staff discussed blood pressure and cholesterol with a vacant Ellen. The first time seeing that. The psychological and physical pain was unnecessary. IDOC could have transferred him upon deterioration as policy requires. And I could pull that up if anyone wants to look at that. I think it's interesting. Even an isolated infirmary cell would have been better than the whole designed for punishment. That's a powerful statement right there. Likewise, the court could have moved him when the court learned of his dire condition. Yeah, maybe she could have moved him and not left and, made claims that the attorneys just wanted him closer to them, which was bullshit. The constitutional violations require suppression. Over 150 years, oh my God, who is this person? Dostoevsky? That's like I should know that name. Dostoevsky wrote the decree, I never read this obviously, assimilation in a society can be judged by entering its prison. Yeah. Davis. In 2015, writing about the effects of solitary, Justice Kennedy hearkened to this quote, noting, there is truth to this in our own time. Applying the exclusionary rule to these constitutional violations would deter abuses within our prison system and law enforcement, protect judicial system integrity by showing it condemns such conduct, and protect the human dignity of those unable to make bond while awaiting trial. Indiana has a robust exclusionary rule relying on Article 1, Section 1114. Indiana adopted the exclusionary rule long before the 14th Amendment. Wow, that's interesting. Exclusionary rule applied to states. Members, the state, 1923. Under the exclusionary rule, to determine whether a statement is a product of illegal detention, the court must ask if the statement has been come at by exploitation of that illegally or instead by means sufficiently distinguishable to be purged of the primary taint. The court considers 1, the time elapsed between the I can't say this word. Illegality. Oh God, am I saying that? And the acquisition of the evidence, the precedence of intervening circumstances, and 3, the purpose of flagrancy of the official misconduct. First, Allen's statements occurred during the illegal, oh my gosh, I'm going to say the illegal. Oh my God. I can't say that word, everyone. Sorry, I suck. Illegality of his detention at WCU. Second, there were no intervening circumstances. Again, there is a well-known connection between solitary confinement and psychosis. Williams. Third, the constitutional violation was flagrant because IDOC. No, yeah, a half of one, Heather. Because IDOC violated its own policies for keeping Allen safe, and the court and prosecutors referred to help when Allen's attorneys warned of his deterioration. Even if this court finds Allen's statements were voluntary because he was not interrogated by law enforcement, he was still gravely disabled when he confessed. As such, his free will did not purge the taint of his illegal detention. The trial court erred by denying the motion to suppress. The error was not harmless. Before a federal or state constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt. Chapman v. California, Torres v. State. No piece of evidence may have greater sway over a jury than a defendant's confession. I agree with that. That's so true from every case I've ever seen play out. Missions of the statement to Satan alone were prejudicial because they were a large part of the state's case. The prosecutor particularly concentrated on Allen's May 3rd statement, arguing that Allen knew a fact only the killer will know. Oh my gosh. That other people knew? Okay. The confessions also countered Allen's confinement and unwavering pre-solitary protests of innocence. I need to take a drink. Sorry. It's a lot of words. How's everyone doing? Did I put anyone to sleep yet? Oh, shoot. Where did I end up? Okay. The court denied Allen's his right to protest a complete defense to explain the scene and impeach. Okay. So I think that's it then on this topic, right? Because now we're talking about a complete defense. Oh, wait. No, it's a separate issue. 3. Hold on. Let me go up. What page was I on? I don't know what page I was on. Excuse me. 1, 2. Yeah, separate issue or separate category. So, yeah, wow. That was really well put together. Like I said, I didn't read the whole thing. I just skimmed over it. So I am it's a lot to process. What stands out to Heather? What stands out to you or anyone else that's still here that I didn't put asleep or bore? Maybe let me try to find that policy real quick that I was talking about. I have it. And I think I have it in like 5 different locations because I never can find it. So I should be able to find it. Let me unshare this. How long have I been going at it? Okay, so I'm like still under 2 hours. That's good. So let me see if I can find it. Okay. What a bunch of assholes. I'm sorry. I'm still processing this. Okay, cool. I have a lot of cool stuff in here, actually. Okay, before I forget, let me just share this. If anyone's seen this. Because this is a really cool document that I found. Has anyone seen this? So this is, I believe I found this is like a handbook that was put together for prisoners, like people that are doing their own appeals. And this is just one chapter of it. So it says the rights of pretrial detainees. There's many other chapters, but it's like written in layman terms, and it has a lot of good case law in here. Here's something on confessions, voluntariness. The confession you make to the police must be voluntary in order to be used at your trial. The word voluntary may be confusing, however, because it actually means it's something like not coerced in this context. See, and then look at 26 here refers us to the Colorado v. Connolly. I think that was mentioned a couple times. To coerce someone means to pressure that person into doing something by the use of force or threats. Several things can make a court decide that your confessions was not voluntary. The police cannot use or threaten to use physical violence in order to get you to confess. If the police threaten to administer a painful medical procedure in an attempt to get you to confess, even though they may be legally entitled to order this procedure, the court may consider the statements you make after this threat to be involuntary. Your confession is not likely to be considered involuntary simply because it occurred after the police interrogated you for a long period of time. But if you were subject to a long interrogation and were deprived of food or sleep, your confession may be deemed involuntary. Likewise, if you were held in a very bad conditions for your interrogation, courts may find your confession to be involuntary. In addition, the use of deception or promises of leniency in sentencing can sometimes make the confession involuntary. So that was, this is an Illinois case. If your confession is involuntary, that is, if it was been improperly compelled, it cannot be used at trial for any purpose. 33. I didn't think I've seen this one being mentioned. The Mincy v. Arizona, noting that any use of at trial of an involuntary statement violates the defendant's due process right. But we've seen this Miranda v. Arizona, I think. Okay, here's one. The Spano v. New York, finding a confession involuntary in part because the suspect was subjected to prolonged interrogation at almost 8 hours. Ashcraft v. Tennessee, finding of a confession course when suspect was questioned for 36 hours without sleep or what. Mincy v. Arizona, holding that the statements of a suspect were involuntary when an interrogation lasted 4 hours while the suspect was severely injured. That's interesting. Oh, okay. But it's just like cool. I mean, I just like it because it kind of, like I said, it's like layman terms, but it has like a lot of cool case law in here. You know, the Sixth Amendment. I kind of wonder why. I don't know. I didn't read the whole thing, so I should shut up. But like, I always thought like the Sixth Amendment should be in play a little bit here. And then they have this test here, deliberately illicit test. So there's like a standard here. But this is like Sixth Amendment. So under the Sixth Amendment at trial, the state may not use incriminating remarks that were deliberately elicited from you after you were charged with a crime under certain circumstances. A remark is deliberately elicited if the government purposely caused you to make statements against yourself. These incriminating remarks may not be used to trial if 1, the statements are about the crime you are being charged with, and 2, you have not waived your right to counsel. Determining exactly when the state deliberately elicited incriminating statements can be confusing. The Sixth Amendment is not violated just because a state receives incriminating statements by luck or happenstance. Instead, the government has deliberately elicited statements whether it purposely creates a situation where it is likely that the defendant will make incriminating statements without the assistance of counsel. In addition, the government is also considered to have violated the test when it knowingly takes advantage of a situation to interrogate the defendant without counsel present. Proof that the state must have known its agent was likely to receive incriminating statements is enough to find a Sixth Amendment violation. And then here it's like, see how it like kind of like talks to you, like if it's talking to defendants. But anyway, not that you guys are defendants, but you know what I'm saying. You may be able to better understand the deliberately illicit test by learning about 2 of the Supreme Court's Sixth Amendment cases. In Messiah v. United States, defendant Messiah and his co-defendant Colson were charged with drug crimes and then released on bail. Without Messiah's knowledge, Colson agreed to cooperate with the police. Colson allowed the police to put a radio transmitter under the front seat of his car so the police could listen to conversations taking place there. Colson then had a conversation in his car with Messiah while the police listened. During this conversation, Messiah made incriminating statements which were used in his trial and led to his conviction. The Supreme Court reversed Messiah's conviction, finding that federal agents had deliberately elicited these incriminating statements from Messiah after the Sixth Amendment right to counsel had been triggered. Even though the interrogation was not conducted in police custody, and despite the fact that Messiah was not aware he was being interrogated, the Supreme Court held the Sixth Amendment protection still applied. For the Sixth Amendment to have any force, the Supreme Court said it must apply to indirect and surreptitious, I always have a trouble saying that word, undercover interrogations, as well as those conducted in the jailhouse. United States v. Henry, another Sixth Amendment case, shows how the state use of paid informants to elicit incriminating statements can sometimes make these statements admissible. In Henry, the defendant was charged with armed robbery and placed in jail to await trial. An FBI agent contacted a paid informant who was in the same cell as Henry. The FBI agent told the informant to listen to what Henry said and report back any incriminating statements that Henry made. By telling the informant not to question Henry, the FBI agent was trying to comply with the Sixth Amendment restrictions on eliciting incriminating statements. The paid informant talked to Henry in prison about the charged crimes. So the Supreme Court found that this arrangement violated the Sixth Amendment by interfering with Henry's right of counsel. So here's the thing. Like, yeah, Indiana might have this special rule that, incriminating statements made, in treatment involving a homicide is okay under their state law. But like, I mean, I'm not an attorney. And if you see like this banner, going down, this is not legal advice. But to me, Dr. Walla is a state agent. She might be a third party, a contractor from a state agent, but to me, she's like using therapeutical means to elicit a confession. God knows what she said to him or asked him. So when you combine that with the fact that we have these suicide companions sitting there, God knows what they're telling him, and you got a chaotic environment with a bunch of people screaming to go, KYS, yourself. It's really shady shit. So yeah, this is really, really cool. So I'm trying to figure out, so it's the rights of what is the bigger book called? Okay, a Jailhouse Lawyer's Manual. That's what this is called. But it's really good. I love it. I'm such a dork though, I know. Like reading legal shit. Anyway, I was looking for, sorry, my ADD. I was looking for, I'm going to show you all the manual. Okay. Is this what I need? Okay, this is, I'm not going to share this one. Policy and Administrative Procedure, Manual of Policy and Procedures for Offenders with Physical Disabilities. That's not the one I'm looking for. Let me see. Protective Custody, Function and Process. Okay, so this is the classification. One second. I'll find it. Intake unit. Okay, here it is. I got it. Here's receipts, y'all. All right, I'm going to share my screen. Okay. Okay, so what I'm looking at, or what we are looking at here, is now this was 2023. Okay. Safekeepers. Whether a facility is contacted by a court or sheriff's department about housing a safekeeper, the warden or designee shall refer them to the Director of Operational Support Services. The director/designee shall review the request, the safekeeping order, and complete State Form 47723 checklist for safekeeper. They shall forward a recommendation to the Chief of Staff or Deputy Commissioner of Operations for final approval. The director designee will advise the court sheriff's staff with the designated per diem costs for housing and medical care, which will be billed to the requesting county on a monthly basis. In order to ensure the county is kept informed, the facility employee, let me make this bigger. Okay, sorry. Okay, assigned to monitor safekeeper accountability for the facility shall complete a report monthly advising as to the safekeeper's behavior, adjustment, medical condition, visits, and other pertinent information. Additionally, this report shall include any costs that will be billed to the referring county for that monthly period, including housing and medical costs. This report shall be submitted to the warden for review and approval and then forwarded to the county sheriff. A copy of this report shall be forwarded to the Director of Operational Support Services. So here's the thing, like it's saying here that they're going to, they prepare a report with costs and yada, 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 but also they include the safekeeper's behavior, adjustment, medical condition, visits, and other pertinent information. And this report goes to the county sheriff. So I'd be interested in what the hell was in that report, because but surely they should have provided some medical conditions, maybe not like specific like diagnosis, but I mean, is banging your head against the wall a behavior? I would say yes. So shame on Carroll County if they got this information and sat there and did nothing. If I don't know what's in this report, just saying. Okay. Safekeepers shall be classified to the least secure facility for which they properly qualify. The underlying principle shall be considered what is the best interest of the safekeeper, the community, and the department. This will also ensure adequate security and custody are maintained in order that the safekeeper is available to the court when ordered. Safekeepers generally will be housed in department facilities and not in contract facilities. However, safekeepers who present serious mental health issues may be housed at the New Castle Correctional Facility if it is determined that they are in need of services in the psychiatric unit. So what constitutes as a serious mental health issue? I would say, putting feces all over your body and drinking out of the toilet and thinking World War III is kicking off. And I mean, we just went through all of that. I would classify that as a serious mental health issue. How about hell though? Like, would that constitute like, hey, it's being used to treat a serious mental health issue? The procedure for maintaining safekeepers shall be consistent with the procedures for sentenced individuals. So here's the thing too. I don't like that the talking points that I hear the pro-guilters say here when they're like, well, he wasn't an offender or an inmate, so they didn't know how to deal with him. Right here, it clearly states that the way you maintain a safekeeper is consistent with the procedures for sentenced individuals, which would be 30 days in solitary confinement. 30 days. Okay. Then here it says predispositional diagnostic services. The following facilities are designated to conduct court order predispositional diagnostic services. So we got Rockville Correctional Intake. That's for females. And then Reception Diagnostics or whatever Center, RDC, adult males who are convicted but yet not sentenced. So again, the procedure for maintaining safekeepers should be consistent with the procedures for sentenced individuals. Right here, the RDC, it was the adult males who are convicted but yet not sentenced. So again, everything else, incarcerated individuals, right? That all still goes under this bucket for the procedure is consistent with sentenced individuals. So I'm not trying to hear any more people say they didn't know how to handle them. So yeah, so this is the policy and administrative procedure, manual of policies, and then this is number 14101. So if you go to the IDOC's website, and there is a place where you can look at all the policies and procedures, this is the number 0104101. So yeah, receipts, y'all. Yeah, no one fakes that. You are right. Excuse me for clearing my throat. That was a lot of reading, a lot of words. Did you? You know who got me this sweater? My 16-year-old son got me this sweater for Christmas. Wasn't that nice? He got me this one, and he got me a hoodie, and it's really, really soft. Hebby says, I've seen some of the Guantanamo Bay prison stuff, and Ricky looks worse than some of them. Literally. I agree. I'm sorry, but throwing feces at guards are one thing, but eating it a whole another story. No one fakes that. Yeah, it's like, I mean, for him to fake all those symptoms, like, I would say he would need like medical knowledge, like to the point of like studying the shit in school. There's certain things you just can't fake. And you know what? I was looking at other claims of like eight amendment violations online for Indiana. And Walla's mentioned in like several suits, and it's the same excuse she has, like at every single time. He was malingering. That's her like go-to. Sorry, yeah. So you know, Hebby brings up a good point too. Like, you don't give Haldol to somebody who is not in a serious mental state, right? So which one is it? Did you misdiagnose him and drug the dude for no apparent reason? Because, or which one's more likely? Or that, or he had a serious mental issue and she was treating him for such serious mental health issue. So, yeah. I think I'm done with my presentation today. It was a lot of reading. I hope y'all took back something from this. You probably all like listened to many people read this by now. Ever seen those dare shows where people have to eat bugs or gross stuff to win money and most can't? They gag and puke. Imagine eating poop as a sane person. Doesn't happen. Yeah. Agreed. Good point, B. Well, I think I'm going to wrap this up. It's getting late. Thank you for joining. It's great comments in here. Thank you to, let's see, Criminal Network, Heather Brown, HCC was in the house. B, I think I got everyone. Thank you. It was great chat. Thanks for stopping by. And I hope you all have a nice weekend. If I don't go live, or just in general, I hope you have a great weekend. So thank you. Good night, everyone.